Where have we not heard those immortal lines, "I am going back to mother"? To modern ears, it sounds like a line from a Terence Rattigan or Noel Coward play performed in the West End. But women did go back to their mothers. Not because of maternal love, but the attitude of society towards single women seeking rented accommodation. They all claimed to be respectable, hard-working types, but what was their actual profession? There was also the problem of emotional damage. What respectable landlady wants the ex to show his presence by creating a scene and darkening the doorstep again? Everyone knows that a respectable lass stays at home with her parents until she is married. It stands to reason. As in the case of many episodes of West Country murders, Milborne Port is a sleepy village on the southern tip of Somerset near Dorset. Its main claim to fame is that it has a geological feature of Fuller's Earth. But even the sleepiest place contains all aspects of human behaviour. Home the woman went, and dreadful scenes ensued. James will tell you a tale of one such incident and an actual change in the law that happened.
This episode covers events at Milborne Port in the eastern part of the southwest of England county of Somerset. Contrary to what the name of the place suggests, it is nowhere near the sea and is in fact landlocked apart from the River Gascoyne, which flows into the better known River Yeo that runs through the rural agricultural landscape. In Old English, the word port refers to a place that is a thriving market town, and so it was in 1934 that events took place that literally changed the course of British legal history. At the time, it had a population of a little over 1,000 people, and two of these were 21-year-old Reg Wilmington, a farm worker, and Violet Smith, a glove maker, who on the 25th of August of that year was the day of their marriage in the local church. Sadly, it seemed that the union would be beset with difficulties from the start. The couple had known each other for a few years, and 17-year-old Violet was now heavily pregnant. They had nowhere that they could call their own home, and as a consequence moved in with Reggie's parents, who had a small and cramped cottage on the outskirts of the town. Hardly ideal for the newlyweds. Luckily for Reg, he soon found a job on a local farm down the road, which came with a tied cottage in a village called Castleton, which is near Sherborne in Dorset. This was after having lived with Reg's parents for 2 months in their overcrowded cottage. It came as a great relief that the couple finally had a place that they could call their own. It was not long after they had moved in that Violet gave birth to their son. Sadly, being married and being a mother did not work well for Violet and her expectations of domestic life. The house they lived in was quite isolated, and dealing with the needs of a newborn child, as well as other daily chores, together with her new husband working long hours on the land, caused Violet to become depressed and lonely. Her mother would be a frequent visitor to the household, but her very presence seemed to make the whole situation worse for some reason, and contributed to increased mental stress. Before she was married, Violet had worked alongside her mother as an outworker, making gloves for a local manufacturer. When she got married and moved out, the mother, Lily, felt the loss of her daughter's presence, and especially the additional income, which meant she visited Violet regularly, and she would often take up unmade gloves with her. She and her daughter would work at home together while the baby was asleep. Reg felt his mother-in-law was continually conspiring to persuade Violet to leave him and return to her former home in Milborne Port. What he saw was Lily's interference in their marriage, which became the cause of numerous rows and arguments between the Wilmingtons, and it all came to a head on the 22nd of November 1934. That day, when Reg returned home to have his lunch, he found his mother-in-law in the cottage. Violet told him that she and her mother were going to go for a shopping trip to the nearby town of Sherborne in the afternoon, and that they would be taking the baby along with them. Reg got annoyed at this and said it was far too cold to take a 5-month-old baby out into the cold for such a long time. But his wife refused to listen, insisting that they were going out whether he liked it or not. Unsurprisingly, Lily took her daughter's side in this disagreement, at which point Reg completely lost his temper. He told his mother-in-law to stop interfering with himself and his wife, and to go home and leave them alone, at which point he stormed out of the cottage and returned to work. Returning that evening after a long day's work, he found the cottage was empty, with no wife, no baby, and especially no mother-in-law. On the mantelpiece over the fireplace, he found a note from Violet which read, "I've gone home. Don't come along. I've asked my mother to take me in, and I made my mind up to get a job as a lady's maid." Reg was very distraught at this news and was determined to make every attempt to get Violet to come home. He pleaded with her, but it was to no avail, being adamant that she wanted nothing more to do with her husband, and this was, as far as she was concerned, the end of their brief marriage. Reg was desperately missing his wife, and in early December a chance meeting with his brother in Sherborne proved to be the catalyst for events that were eventually to change the face of British justice. Reg had heard from his brother that his now estranged wife had gone to the cinema with another man, and it seemed to him that he had already been replaced in her affections. This was the last straw for the abandoned husband. He did not get any sleep that night and went to work the next morning to do his usual jobs around the farm. While at work, he took an old shotgun that belonged to his employer, and in the shed sawed off the barrels and attached a loop of baler twine around the gun so that he could hang it from his shoulder. With the weapon concealed under his overcoat, he cycled to his mother-in-law's home in Milborne Port. Violet's aunt, Daisy Brine, who lived in the house next door, was hanging out her washing in the garden when she heard a man's voice that she recognised as being that of Reg. She overheard him saying, "Are you coming home or not?" She didn't recall any reply, and the question was almost immediately followed by a loud bang. As Mrs. Brine ran to investigate the noise, she saw Reg run out of her sister's house and get on his bicycle and pedal off. She found Violet lying dead on the floor, shot through the heart. The baby, thankfully, slept unharmed in his cot, and there was no sign of Violet's mother, who perhaps fortunately was not at home at the time of her son-in-law's visit. Reg cycled back to his parents' home, where he told his horrified mother, "I've gone and shot Violet." From there he cycled back to work, telling his employer that he would not be coming to work anymore, and that he had shot his wife, before returning to his parents' home, telling his father he was going to kill himself. The father managed to keep his son talking until the police arrived, and when Reg was arrested and charged with the murder of his wife, he made a comment saying, "I won't say anything except that I did it, and they can do what they like with me. It was jealousy. I suppose her mother enticed her away from me. I have done all that I can to get her back, that's all." Searched by the police, a note was found in Reg's overcoat pocket, which confessed his crime and his hatred towards his mother-in-law, as well as his now deceased wife, and that as such he was going to commit suicide. In his despondency caused by the end of his marriage, he felt his own life seemed useless. He felt worthless, having lost the love of his life and his son, so seemed reconciled to be going to the gallows for having killed his wife. By the time he appeared at the County Assizes in Taunton on the 23rd of January 1935, he seemed to have undergone a change of heart. He was now claiming that Violet's death was a tragic accident. He maintained that he had no intention of killing his wife when he visited her mother's home in Milborne Port, but had intended only to frighten her by threatening to kill himself in the vain hope that this might change her mind, so that their marriage could be given a second chance. He maintained that when he pulled the gun from his overcoat, it accidentally went off. He insisted that his finger never went near the trigger. He told the court that he did not intend for the gun to go off, or to injure his wife in any way. He explained more about the note that was found in his pocket on the day of his arrest, saying that when he realised that he killed his wife, he intended to commit suicide. Rather than writing the note the night before the shooting, it was actually written at his parents' house after her death. The barrister for the accused, Mr. J.D. Caswell, was acting in his defence and called an expert gunsmith who had examined the sawn-off shotgun and found it had an exceptionally sensitive trigger pull, which could, in certain circumstances, go off accidentally. The counsel for the prosecution, a Mr. Trapnell, argued that the accused had shot Violet in a jealous rage. Caswell insisted that there had been no intention to commit a murder, as the husband loved his wife far too much to want to harm her, and all he wanted was to persuade her to return home with the baby. Mr. Justice Findlay, the judge, summed up the evidence to the jury, who retired to consider their verdict. When they returned, they informed the judge that they could not reach a verdict on the case, however long they had debated it. This left the judge no choice but to discharge them in order a retrial to be held at the next Bristol Assizes, which was listed to take place on the 14th of February. The second trial was held by presiding judge Mr. Justice Swift. It went in a similar way to the preceding one, until it came to the summing up. In the course of his summary, the judge referred to a book entitled Archibald's Criminal Pleading, from which an extract was read to the jury. It goes as follows. All homicide is presumed to be malicious murder, unless the contrary appears from circumstances of alleviation, excuse, or justification. In every charge of murder, the facts of the killing being first proved, all the circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner, unless they arise out of evidence produced against him. The judge went on to clarify the meaning of the passage in layman's terms, telling the jury that it meant that it was for the guilty party to satisfy a jury that his crime was anything less than murder. He stated the charges made against Reginald Wilmington, that the prisoner at the bar of wilful murder. It had been stated on the morning of the 10th of December, at about 9:30 in the morning, he had murdered his wife. She had died while he was in the house, of which there was little doubt. It is a matter entirely for the jury. The judge continued, if you come to the conclusion that she died as a consequence of injuries from the gun which he was carrying, you are required by the law of this country into the following position. The Crown has got to satisfy you that this woman, Violet Wilmington, died at the accused's hands. They must satisfy you that beyond all reasonable doubt. That must satisfy you beyond all reasonable doubt. If you are satisfied of that, then he has to show that there were circumstances to be found in the evidence, which has been given from the witness box in this case, which alleviate the crime. If you are satisfied of that, then he has to show there were circumstances to be found in the evidence, which has been given from the witness box in this case, which alleviate the crime to manslaughter, or which excuse the homicide, by showing that it was an accident. The jury retired to deliberate, and when they came back to court, the foreman gave a verdict of guilty of wilful murder against the accused. The judge took the only course of action that he had at his disposal and gave the death penalty. Naturally, Registered Defence Counsel wasn't impressed by the verdict. To him, the judge's summary seemed to go against what he believed was the basic principle of English criminal law, that a man was presumed innocent until the prosecution had proved his guilt beyond all reasonable doubt. Caswell therefore immediately announced his intention of appealing the verdict, and on the 18th of March 1935 he appeared at the Royal Courts of Justice. He put forward his application for the leave to appeal. Having listened to both Caswell and counsel for the prosecution, the three appeal judges announced their decision that leave to appeal was denied. Caswell immediately wrote to Sir Thomas Inskip, the then Attorney General, asking for his approval for the case to be heard by the House of Lords. Inskip invited Caswell to his private room at the House of Commons to brief him on the case, and less than 24 hours later, Caswell was notified that the right to appeal had been granted. Wilmington's case was presented at the appeal court. The main grounds were that the previous judge at the original hearing had misdirected the jury by telling them that the onus was on the defence to prove the shooting was accidental. He had failed to inform the jury that it was the prosecution's responsibility to satisfy the jury of Wilmington's guilt beyond all reasonable doubt. It was argued that all the Crown had to prove that there was malice concerning this case. Judge Swift has stated in his summary that malice had to be presumed for the killing. What it came down to was whether or not the judge was correct in giving that direction. It was argued that the problem was more to do with Swift's directions to the jury, that once it was shown that a person had died through the act of another, it was presumed to be murder, unless the defendant could satisfy the jury otherwise. After 2 days of legal wranglings, which was witnessed by a rather bemused Reg, the Lords retired to deliberate the matter. When they returned to the court, they announced that Wilmington's appeal had been upheld, and his conviction was quashed. He was now a free man. Such was the public interest of this case that he was spirited away from the House of Lords by a national newspaper, and the following day was pictured on the front page, with the caption, "It's great to light a pipe again. I knew that justice would prevail, but I will still miss my wife." A few weeks later, the Lords published their reasons for the decision, stating that some of the legal principles concerned dated as far back as the time of King Canute. The main principle to which the original judge referred to in his summing up dated from 1762. It was noted that throughout the history of English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt. If there is a reasonable doubt created by the evidence given by either the prosecution or the prisoner as to whether the accused killed the deceased with a malicious intent, the prosecution have not made their case at court, and the prisoner is entitled to an acquittal. No matter what the charge or where the trial, the principle that the prosecution must prove guilt is enshrined in the common law of England, and no attempt to water it down can be accepted when dealing with a murder case. The Crown must prove firstly the death as a result of a voluntary act of the accused, and secondly the malice involved. So, a cornerstone of English criminal law was established. Now, as a result of Wilmington's case, it has been classified once and for all that all defendants are presumed innocent until the prosecution has proved all aspects of their case to the jury beyond all reasonable doubt. After his acquittal, Reg became a minor celebrity and was offered a number of jobs by some of his supporters and well-wishers, including a stint in the theatre. As was likely, he soon faded into obscurity, and is only remembered by those in the legal profession for whom Wilmington versus the Director of Public Prosecutions remains a landmark case in English law. John, this is very much up your street. What are your conclusions about this very eventful case?
The strange thing with murder is that it has no basis in statute. It depends upon case law and learned law books written by those who have long departed. In the Milborne Port murder of 1934, there was a hung jury followed by a yew trial. This one resulted in a death sentence and the defendants appealed. The problem was that the case law was contradictory, and the Attorney General asked the appeal judges to make a ruling. Their ruling even included a reference to King Canute, though he was not quoted. In the end, they all agreed that the onus was on the prosecution to prove guilt and not the defendant. The only exception was in the case of insanity, where the defendant, or more important, his counsel, had to prove his case. Consequently, the conviction was quashed. He walked away a free man. Interestingly, one of the appeal judges was Lord Atkin. He changed the law of negligence in the case of Donahue against Stevenson, in which a Scottish lady drank a bottle of ginger beer and became ill. The key point was that she did not enter into the contract to buy the ginger beer. The manufacturer was still liable.